Ellen and Howie here with another one of our educational videos meant to explain legal terms in plain language for our viewers. So today's topic is, what is the difference between a trustee or an agent? Basically, both are fiduciaries, so what is the difference between them? So Howie, let's start with an agent, or person who's acting under a durable power of attorney, which is also known as an agent, because I think that's the more common one that people understand.
Sure. So if you're appointed as an agent under a durable power of attorney, the power of attorney itself will set out all of your powers and authorities to act on behalf of another individual, who's usually referred to as the principal of the power of attorney, and they've appointed you to handle their affairs. So as their agent, you are given certain authority to go to banks, deal with life insurance companies, annuity companies, various government agencies, to contract on behalf of this other individual, and you are their agent for legal purposes to carry out anything that they could carry out as long as the power has been specifically set forth in the power of attorney document.
So basically, you step into the principal's shoes as an agent.
Yes.
What if you can't find the original durable power of attorney under Florida law? Is it still okay to use a copy?
It is, and that wasn't always the case. As we know, back in 2011, the law was changed to make it clear that, a lot of people were looking for their originals. Banks and financial institutions were requiring them, and it was really a challenge for our clients to deal with because oftentimes they could not find the original. So as of 2011, October 1st, you no longer need to produce an original durable power of attorney in order to have the authority that's conferred, as long as you have a copy.
Now, if you are an agent, you can stand into the principal's individual shoes. Can you act on a revocable trust that the individual may have set up?
So the only way that you can act on a revocable trust as an agent is if two things occur. Number one, the durable power of attorney itself must contain specific language that gives you the authority as the agent to act with respect to the revocable trust, and the revocable trust also needs to be drafted to contain language that specifically says that if I have an agent under a durable power of attorney, then that agent also has authority with respect to the trust.
And even when that's done, we see issues where we have financial institutions who only want to take direction from a trustee of a trust. Because what we were going to now sort of contrast an agent with is being a trustee of a trust. Because if you are the trustee of the trust, you are the driver of that trust. You are the captain of that trust ship, or you are the holder of the trust umbrella, and the spokes underneath the umbrella are the assets that are titled in the trust. So wherever you as the trustee go, if you use the umbrella analogy, you take the assets of the trust along with you, and you have the control over that trust. So that's the difference in a nutshell between an agent and a trustee.
So one really important distinction is that if you're the trustee of a trust, as Ellen was saying, you have authority over the assets that are in the trust. But if you're an agent under a power of attorney, that doesn't give you authority over trust assets. It actually only gives you authority to handle and to manage and to transact with assets that are not in the trust. Now, if you have an agent and a trustee who are one and the same person, then obviously that person is going to have the ability to manage both the trust assets and the non-trust assets. But if you have a trustee who's different than the agent under the power of attorney, now you really have a division of power and authority, because one can only handle non-trust assets, the agent, and one can only handle the trust assets, the trustee.
What about what you said prior, where if your power of attorney allows the agent to act on the trust and the trust allows the agent to act on the trust, how does that apply?
Well, I think you're going to need to look at the circumstances, right? Because if you have one and the same individual, no problem, they can amend the trust, they can make distributions. But if you have different people and now you have an agent who wants to come in and make a certain distribution from the trust, and the trustee is a different person and says, no, I'm not making that distribution. I don't think that that was the intent behind this trust. I don't think that the person who created the trust would have wanted this distribution to be made. You now have a conflict. Now, in that situation, I think we probably flip it back to you and say, well, what if the agent felt very strongly about that? Would they go to court and say, Judge, I think this distribution ought to be made and the trustee's not complying?
Right, and you would deal with that under Florida law. We have litigation opportunities, or I don't like to say litigation as an opportunity, but we have avenues of litigation where we would have to seek court intervention in order to determine the roles, maybe, to determine the authority, maybe, of the agent and whether the agent has exceeded his or her authority, and determine the roles and the duties of the trustee, and determine whether the trustee is not complying with the proper roles or duties that the trustee may have. And it's a complicated area to make sure that, you know, everyone is doing the job that the principal intended and that the documents bear that intent out.
One other point before we close out. Regardless of whether we're talking about a trustee or an agent, whoever you appoint in these documents is someone or more than one individual who you trust implicitly to carry out your wishes. If you have any questions about the integrity of the person, the trustworthiness of the person that you're appointing, whether it be a trustee or an agent, then that is not the right person to appoint in these documents.
Right. And lastly, when you're appointing two people and giving them equal authority, that's also where you see some contention. So be careful on that as well.
So thank you very much for joining us today. We hope to hear from you. We're here for you as a resource, and we wish everyone well, and please stay safe.